Thank you, everyone, for joining us. My name is Stephen Haddock. I am the current chair. I'm an attorney in New Orleans, Louisiana. I'm the current chair of the FBA, the Federal Bar Association Civil Rights Section. The FBA Civil Rights Section is one of the co-sponsors for this webinar. I'd also like to thank DePaul College University of Law, who is allowing us to use their Zoom platform and is a co-sponsor, and also the National Police Accountability Project, another co-sponsor. So thank you for all of those organizations for helping us to put this together. And I'd also like to thank Robin Wagner, who's the current chair-elect for the Civil Rights Section, and this was her idea and really her brainchild. So today we'll be talking about locked up in a pandemic, the phenomenon, the issue of what you do and what the legal system, how the legal system should respond to the fact that we have somewhere over 2 million people locked up in jails and prisons across the country, and kind of a patchwork, everything from federal to states to tribal jurisdiction. I mean, all sorts of different institutions across the country, with literally millions of people locked down. And as I think most people are coming to understand, I'm certainly learning about viruses and pandemics in a way I never hoped that I would. But it's the reality that institutions like that can be real incubators for viruses. They pose particular challenges when you have a pandemic virus running around. I mean, at the beginning of this thing, people were talking about cruise ships out at sea, and we saw how quickly the virus spread on these cruise ships. So anytime you have a closed system like a jail or a prison, you have a very high risk of the virus getting loose within the prison walls, and lots of people, both the prisoners and the staff members who have to go home to their families and interact in the community, contracting the virus. And of course, how you provide medical care, et cetera. These are very challenging issues. So we'll be talking about the various, legal efforts, the way the legal system is addressing those problems. We have a panel of three attorneys and one organizer, community organizer. And I'll go ahead and introduce them. First, and I don't know how to indicate, to my left on the screen, I'm not sure how to indicate that. We have Sarah Gelsomino. Sarah is a 2008 graduate from DePaul College, University of Law. She's a partner at the civil rights law firm of Friedman and Gilbert in Ohio. I'm not sure if you were in Cincinnati or Cleveland, but Sarah, but she's in Ohio. Prior to joining Friedman and Gilbert, Sarah was a partner at the People's Law Office in Chicago, Illinois. She concentrates in civil rights cases, including police and governmental misconduct, First Amendment litigation, criminal defense, and representing incarcerated people in post-conviction proceedings and conditions of confinement. Sarah also served in the Civil Rights Clinic at DePaul College of Law from 2013 to 2016. She was an adjunct professor there. Next, we have Bruce Hamilton. Bruce wave. Bruce is a staff attorney at the ACLU Foundation of Louisiana here in New Orleans. He's been at the ACLU since 2016. Before joining the ACLU, he worked as a commercial defense attorney, so he's seen litigation from a lot of different angles. And he was also a former law clerk for Justice Kitty Kimball on the Louisiana Supreme Court. Bruce went to obtain his Juris Doctorate, a JD from LSU, and graduated magna cum laude, Order of the Coif, served as associate on the Law Review, and he's also, interestingly, former reporter for the New Orleans Times-Picayune, paper formerly known as the New Orleans Times-Picayune, where he served as a copy editor and reporter for 5 years. Next, we were planning to have, we had asked Mercedes Montaigne, who is the director of the Promise of Justice Institute, located here in New Orleans. She unfortunately had a court hearing that was scheduled. It became a conflict. So she asked Michael Cahoon, who is a political and community organizer at the Promise of Justice Institute, to step in and be on the panel. Before joining PJI, Michael was the lead organizer with SEIU Local 509, a 20,000 member union of social workers, human service providers, and educators. For organizing, he worked in policy research and development for New Jersey After 3, a nonprofit providing school programming. And he has a BA in English and Social Sciences from Bennington College in Vermont. So I'm looking forward to hearing from Michael. I always appreciate in these CLE settings to hear from a non-lawyer perspective, and certainly that's always interesting. So, and last but certainly not least, we have Eileen Rosen, who is a partner at the Chicago firm of Rock, Fusco, and Connelly. She concentrates her practice in civil rights litigation with significant trial experience in both state and federal courts. Prior to private practice, Eileen was assistant corporation counsel for the city of Chicago, Department of Law, where she specialized in defending civil rights cases brought against the city and members of the police department. She obtained her JD from Loyola University, Chicago School of Law, and Eileen is also the past chair of the FBA's Civil Rights section. So the format that we've talked about and that we'll use here is I'll turn it over to the panelists, and each one will take a few minutes to describe what their involvement is with this issue. So there are a number of cases that have been filed, both injunctive class actions, individual attempts to obtain release for individual clients, and so and then other sort of system-wide efforts to address the problem. So each of the panelists will talk a little bit about what they have seen from their particular practice and how the courts are dealing with this. I will be monitoring the questions that people post. So we encourage you to post your questions on the chat, and I will do my best to kind of curate those questions and pose them to the panelists as appropriate and as we go forward. So Sarah, if you would like to start by telling us what you're seeing in Ohio and what your firm is engaged with.
Hi, thanks everyone for being here. My name is Sarah Gelsomino. He is right, I am from Ohio, or my law firm is based in Ohio. I am based in Cleveland. We have offices in Cincinnati as well. And I see so many familiar faces here, people who are doing really important work on this. So to the extent that this forum allows it, I would love to hear what other people are doing and your thoughts on this and how we can move this forward. This is much more than only a legal issue. This is a really important issue for all of society to really rise up now and take a stand against this and do what each of us can to really push our governments to do what is necessary to keep people safe. Before I talk about the litigation that I've been involved in, or the legal work that I've been involved in Cleveland, I think it's important to kind of give context to this and remind people exactly what is happening and why the situation is so dire. Prisons and jails and carceral settings are dangerous on every single day, and now it's just more deadly and dire than ever. These prisons, as we all know, they're tinderboxes for COVID spread. Because of the way that people are housed and caged in prisons, and because of the number of people that we have inside prisons and jails, every day there's simply no way to keep them safe unless there's a major, drastic release of people from inside those prisons. Our office receives countless calls every day from people who are trying to survive inside, as I'm sure many of yours do. And some of the stories that we continue to hear that I want to call out today, I think are really important for us to remember, because often the narrative that is being controlled by the prisons and by the state is not truthful. I still get calls from people who are telling me that they don't have access to masks, they don't have access to soap. Other prisoners are responsible for cleaning cells and cleaning even isolation units, and they're not getting the proper protective equipment. They don't have the soap and the sanitizing equipment that they need. They also don't have the training and the information that is necessary to ensure that they are doing the best that they can and with the limited resources that they have to keep places safe. One of my clients who is HIV positive and incarcerated in a low security prison continues to report that they are required to wash their hands twice a day. And in order to do that, they are paraded through the bathroom together in a line to wash their hands at the sinks that are directly next to each other. He stays with 120 people in a pod. Their beds are about 3 feet away from each other. As the situation stands, there's just no way for it to keep himself safe or anyone else safe. And again, it's not just the people who are inside the prisons that are in danger. This is a major public health crisis outside of the prison walls as well. Here in Ohio, we have had 2 major hotbeds of infection within prisons, many more, but 2 major ones. One is at Elkton, the federal prison, where as of last week, 1 in 4 of the deaths of federal prisoners is coming out of Elkton. And also Marion, which as of last week, over 80% of the prison had tested positive for COVID. The physicians and the ERs and the hospitals outside of those institutions have raised major concerns about their inability to keep up with the infections that are coming out of the prisons. These are in rural places. On any good day, they don't have enough ICU beds to care for people who are potentially dealing with COVID. And now because of the depopulation of counties into these rural places where people are incarcerated, the hospitals are just inundated. That the National Guard has had to be called in. I spoke with a coroner last week who works in one of the rural areas that houses some of our major prisons here, that they're preparing tents, and well, he actually called them death tents, which is terrifying, because they anticipate that the infection and death rates are going to be so high. This is serious stuff. And what is so staggering and I think disappointing on so many levels is that the government knows how dangerous this is. They have acknowledged how dangerous it is, and yet they have just completely failed to do anything to take action. My office, along with another criminal defense firm here in Ohio, filed an emergency petition for mass reprieve. We did this weeks ago when there was only, I think, 1 or less than a handful of positive infections inside the prisons, but anticipating what was going to happen. And we really thought through different options about litigation and what could we do to get people out fast. Because like I said, the only way to keep people safe in the prisons and surrounding areas here is to decarcerate. We have to decrease the numbers of people inside the prisons because there's just no way to keep social distancing inside these institutions right now with this number of people.
Sarah, can I ask, was that filed in state or federal court?
No, so it's actually like a clemency petition. We submitted it to the governor and the parole board. But reprieve is different than clemency because it's a temporary suspension of the execution of a sentence. So what we did was we scoured the law to try to find a way that we could very quickly decrease numbers. And a lot of the mechanisms, including clemency in the state of Ohio, require a hearing. There's a constitutional amendment here that requires victims have a say in clemency and sentencing. And because it's a constitutional amendment, there's really no way around it. But reprieve gives the governor the power and the parole board the power to release people immediately without a hearing. And that's what we need to do. So we, again, gave the state the authority that they have very clearly under the law to take this drastic action. And the governor can, first of all, the response has been nothing. The government has completely ignored this, other than acknowledging the fact that the prisons are very dangerous and that people are going to be hurt inside because of the infection. We've had no official response whatsoever from the governor's office to this. The parole board has failed to acknowledge the fact that this was styled as a class action, essentially. And we laid out a sample rubric for how they can consider and kind of prioritize people to get out. Again, just temporarily, they would have to come back to finish serving their sentences or move for clemency once they got out. The parole board has basically only acknowledged it for the 4 named petitioners and ignored it for everyone else. Again, we filed this way back when there were not a lot of infections and people weren't yet dying, which clearly now is a different situation. As of today, there's 3,890 positives within the Ohio Department of Corrections. And the governor has claimed that he doesn't have the power to do anything about the situation and just tried to pass the buck. But I think it's really important, and I look forward to hearing what Michael has to say about this, because the governors, certainly in Ohio, who has been a real leader nationally in social distancing and shutting down the state early and everything, they've taken extraordinary power. In Ohio, the governor canceled the primary election on the morning of the election. He tried to cancel it the day before. The judge said no. They moved in court. The judge said no, this is too close. It's not okay. On the morning of the election, the governor had the health director issue a health order suspending the election until later. That is an extraordinary use of executive power. So clearly, they are not adverse to making extraordinary moves when they deem it appropriate for the safety of people. But they're refusing to do so because we're talking about prisoners, and this just highlights the dehumanization and the lack of dignity and the way that we think about prisoners in this country. They have a lack of value. So anyhow, this petition for mass reprieve, what I think was really cool is that we styled it as a class action, submitted it to the governor, but what we also did then was change it a bit to make it available for individuals to file on their own. So now when people call us seeking support for individual family members or themselves, we're able to give them a basically fill-in-the-blank petition that lays out what the law is and all the requirements that they need to meet so they can petition the parole board and the governor on their own, because more individuals that are moving to do this as fast as they can, the better. You're gonna have to stop me at some point because I lost track of time here.
No, it's okay. It's interesting. I think in my practice, just real quickly, I do criminal. Most of my work is in federal court, criminal defense, and civil rights. It's certainly been an education to me, these kind of relief valve provisions that are out there in both state and federal law. In federal law, we're releasing 3582, I believe, and 3624 that are sort of buried in the code that never, just very rarely come up. Compassionate release, these kinds of things. And this is really, it's highlighting the necessity of those provisions. But it's also, I think, I think a lot of people are experiencing some frustration that it's not seeming to go anywhere.
Right. And I think the mass actions are really difficult. And one thing I do want to address is one glimmer of hope here is the ACLU and the Ohio OJCP in Cleveland, in Ohio, has filed a class action lawsuit around Elkton. And again, that's the federal prison here in Ohio. It was one of the first ones to really erupt with infections and deaths, and a lot of misinformation coming out of that jail, hiding prisoners. Families couldn't find people, not telling people that their loved ones were on ventilators and dying. Really horrific stuff coming out of Elkton. But this class action was filed, and Judge Gwynn here in the Northern District of Ohio just granted in part a preliminary injunction, which has required the government to identify all of the medically vulnerable prisoners and submit like a reevaluation of their sentences and whether those sentences can be enlarged to include so that they can be allowed to finish serving their sentences in some not inside the prison, or maybe not inside that prison, which raises questions about how safe it is to be transporting prisoners from Elkton to any other institution because of the spread of the virus that way. But looking at house arrest, looking at temporarily suspending the sentences, furloughs, halfway, all these other things. So the government had actually submitted that list this morning, is my understanding, and we'll see what Gwynn does with it. Of course, they've also moved to appeal the decision and tried to stay the proceedings pending the appeal, but at this point it's still going forward. And I saw one of the questions was about the Prison Litigation Reform Act and how that plays into these cases, particularly the exhaustion requirements, which is an issue not just, well, for a lot of these things, right? For compassionate release, there's an exhaustion requirement for habeas. It limits a lot of prisoner actions, but Judge Gwynn here got around it by saying that this class action is styled as a habeas and that the PLRA doesn't apply to a habeas. But I think that his opinion, which if it's not one of the materials, I can try to see if we can submit it to you guys, because it's really, I think, worth a read because it highlights some of the complications around how to style these actions. A lot of courts are saying that these are appropriately 1983 conditions cases. That doesn't really allow for immediate release, though, which is what is necessary. We need to get people out right away. But also sometimes because people are asking for a temporary suspension of a sentence, maybe not a complete release, it's not necessarily, or it's not perfectly fitting into the habeas either. There's not an answer to that question right now, but I think Judge Gwynn highlights, kind of the fact that this can be considered either way. But in this case, particularly for medically vulnerable people, because they're not seeking a release, they're seeking an enlargement of their sentence, he deems it to be an appropriate habeas action and is requiring this list of medically vulnerable people to be delivered very quickly to him so that they can take action right away to get at least this population of prisoners out safely.
Yeah. That's kind of a good segue to talk to turn to Bruce to talk about what the ACLU is doing. I know they have filed a federal case against, against Oakdale here. So PLRA is not as applicable there, I suppose, but it is in federal court. And what's the status on that case, Bruce?
Well, unfortunately, the judge granted the defendant's motion to dismiss last week. But I still want to talk a lot about the case because it highlights some of what Sarah was talking about, which is this sort of theoretical between habeas and 1983 actions, which I think is a really interesting kind of emerging area of law. Can everybody hear me okay? Okay.
Yeah.
Well, I want to just start off by talking a little bit about decarceration because, clearly mass incarceration is a huge problem in this country, and it has been for long before the coronavirus pandemic. And it's no secret that the ACLU nationally has made it a major goal to reduce the populations of America's prisons. And that is certainly a goal shared by the Louisiana affiliate of the ACLU. However, when we talk about decarceration in this context, we're not always talking about simply giving people back their freedom and letting them out of the jail. In the Oakdale case, the Levis versus Myers case that we filed against the federal prison in Western Louisiana, we very clearly defined the term release in our briefing as referring to the discharge of incarcerated persons from the physical confines of Oakdale, not necessarily release from custody. The release options we floated to the judge could have included release to parole or community supervision, a transfer furlough as to another facility or hospital or halfway house, or a non-transfer furlough, which could have entailed returning a person eventually to Oakdale once the pandemic was over and the viral threat was abated. And any releases that we asked for would have included requirements for testing, care, and social distancing as informed by a health expert that we also requested to oversee this. I think it's important to make that distinction just because certainly we are advocating for decarceration in a lot of cases, getting people out of jail and getting them released from custody, but that's not specifically what we were asking for in Oakdale. And we weren't telling the judge, hey, just throw open the gates and let people out willy-nilly. And this distinction between release from physical custody and releasing them generally kind of underscores the judge's logic in his ruling in a motion to dismiss and emphasizes that kind of theoretical distinction between habeas and 1983. But there are three actions I want to talk about briefly. I've probably bitten off more than I can chew, but there are three litigation vehicles we used at the affiliate to contribute to this general effort. And two of them were sort of existing cases we had on our docket already. The first case is a class action we filed back in May of 2015 with the Promise of Justice Initiative. Shout out to my fellow panelist, Michael. And that was a class action that asserted basically two claims, an ADA claim because the prison was not accommodating prisoners with disabilities, but also an Amendment claim. And as many of you probably know, the Eighth Amendment prisoners' right to medical care, and the classic formulation really is that prison officials may act with deliberate indifference to a serious medical need. We had a 3-week trial in that case back in October of 2018, but incredibly, we still did not have a ruling. We knew in February of this year that the judge was going to rule in our favor because she issued a notice saying that she was prepared to rule in our favor that certain aspects of the medical care at Angola were unconstitutional, but she ordered the parties into settlement discussions. Then came Corona, and those discussions didn't happen. But while all this was unfolding, we heard of a plan by the Louisiana Department of Corrections to sort of migrate COVID-19 positive incarcerated people to Angola, which is, very large. It's 18,000 acres in a kind of remote part of the state, and houses about 6,000 incarcerated people. And we just thought this was a horrible plan, so we used the existing case to, well, first we sought emergency to find out about the state's plan, and then we filed for a TRO, which pretty quickly denied, and I won't get into the details. Michael can certainly talk about that case. The second case I'll mention is Heredia Mons versus McAleenan, which we filed in March 2019 with the Southern Poverty Law Center in the Washington, D.C. district. And we filed that case against the New Orleans Field Office of ICE, Immigrations and Customs Enforcement. And we had 3 essential claims, a due process claim, an INA claim, and an APA claim. But it boils down, the nut of it really is that the government was not filing, that ICE was not following its own rules. And by that I mean its parole directive. Many of you probably know that when asylum seekers come to this country and declare themselves and their intention to seek asylum, they're given what's called a credible fear interview. And if they pass that, they are eligible for humanitarian parole so that they can be released from custody while they are, fighting their case. And there are certain categories under the parole directive for aliens that can be considered for humanitarian parole, like pregnant women, juveniles. But there are 2 that I really want to highlight: aliens who have serious medical conditions where continued detention would not be appropriate, and aliens whose continued detention is not in the public interest. What we found in this case is that during the Trump administration, the rates of parole grants in the New Orleans ICE field office region, which comprises 5 states, dropped precipitously. So no one was getting out on parole, and that has continued pretty much to this day. We did win a preliminary injunction in September of 2019, and the judge essentially told the government to follow its rules and provide a case-by-case determination of each asylum seeker's request for humanitarian. But the rates have remained incredibly low, and we've since been fighting a battle to sort of show that the government is not in compliance with that order. In the context of this pandemic, we decided to file for a second emergency motion for an injunction. And we argued that essentially ICE should reevaluate applications for humanitarian parole based on those factors I mentioned, because aliens who have serious medical conditions really has to be, that category has to be re-emphasized in the context of COVID-19, because as we've been discussing, it presents a really major health risk for folks with pre-existing medical conditions or comorbidities. And we also argued that it's essentially not in the public interest to hold many of these asylum seekers, especially when social distancing is such a problem in the facility. That preliminary injunction motion also failed. The judge held it in abeyance for a little over a week and heard some argument at a status conference, but it was sort of beyond the scope of our case. We tried. The third case I'll mention is Oakdale. And we targeted Oakdale essentially because that facility, it's in Louisiana, federal prison with, it's essentially two big compounds, but one facility with about 1,800 incarcerated people. It's where the first inmate in federal custody died from COVID-19. And it's pretty clear that Oakdale has a bit of an outbreak there. And I think the total is now 7 deaths of prisoners at Oakdale. At least 20 of the staff have tested, 50 of the incarcerated people there have tested positive. So we brought a habeas action there, and we asserted an 8th Amendment claim. This was also a putative class action on behalf of about 9 named plaintiffs. And we as I mentioned, we argued for release as I defined it, and for that whole process to be overseen by a public health expert. And we asked for, we defined the class as such that the whole class covered everybody at Oakdale, but there was a subclass of medically vulnerable people. The interesting thing about this sort of distinction between habeas and 1983 is if you look at the case law, the shorthand is really that when the fact or duration of confinement is at issue and release is the remedy, habeas is the preferred route. And if prisoners are challenging conditions of confinement, 1983 is the method. And you should be able to actually plead these in the alternative. But we brought this as a habeas action. We asserted the 1983 claim, and I think the judge, had some problems thinking of it as something other than a conditions case. But the interesting thing about COVID is it's really changed the way we think about this, in the sense that it has turned the condition of incarcerated into a condition that affects the fact or duration of confinement. And many of you probably know that the Supreme Court has really left open the question of whether you can use a writ of corpus to obtain review of the conditions of confinement. And the Fifth Circuit, really, where my office sits, also has sort of left open that door. I don't want to take up too much time talking about the details of that case, but the judge, as I said, granted the government's motion to dismiss, and he sort of that we were arguing about the placement of prisoners, and he dismissed it. He said he didn't have subject matter jurisdiction for the habeas claim, and I'll just read a couple sentences from his opinion. He said that in this case, petitioners do not and cannot contend that their imprisonment or custody itself is unlawful. They are convicted of certain crimes, were properly sentenced to serve terms of imprisonment, and then were assigned by the Bureau of Prisons to serve those terms of imprisonment at Oakdale. And that sort of misses the entire fact of the unconstitutional conditions of confinement. We brought an 8th Amendment claim because we were essentially saying prison officials are aware of the risk of serious harm that COVID-19 poses, and the failure to reduce the population and allow for social distancing, and the failure to mandate the use of personal protective equipment and increasing the sanitation and hygiene at the prison, all of that sort of amounts to an 8th Amendment. Obviously, the judge wasn't buying it, but obviously, we think his opinion is wrong. It's wrong in several respects, but it'd be very interesting to contrast Judge Doty's opinion with Judge Gwynn's opinion. You can see Judge Gwynn really struggling with Habeas versus 1983 in that. And one of the interesting distinctions he makes is because that case also had a larger class of everyone incarcerated at Elkton and then a subclass of medical people, he draws a distinction and says basically because we're getting the medically vulnerable people out, that's Habeas, but because we're increasing the capacity for social distancing by reducing the density of the population, their case sort of sounds in 1983 as a conditions case. So that's just an aspect of the law that's emerging here that's kind of exciting to pay attention to. But I want to be mindful of panelists' time.
Sure. Yeah, sure. It's an interesting, the PLRA does have provisions, and there was a question from the audience about the PLRA. Of course, the exhaustion requirement, there's been a recent Fifth Circuit case that just came out not too long ago where they dismissed a claim it was arising out of Texas, and they dismissed they reversed. The judge had issued an injunction against the Texas prison, and the Fifth Circuit panel vacated that because no one had even tried to exhaust. But one of the judges said, well, look, things may be different if they had at least tried, if they had at least filed a grievance. Maybe they hadn't completely exhausted yet, but here they didn't even try. So, if you have clients out there, I think the lesson is, even if you don't have time to exhaust, go ahead and file the grievance so that at least you can say you're trying to do that.
Yeah.
So.
Well, you can certainly argue that the grievance procedure is not available, or it's simply
right.
impracticable under the circumstances. Just to highlight, at Oakdale, the grievance process requires, I think, a first step that you file your grievance and then you wait 30 days. So if the takes advantage of the maximum amount of time it has to respond to that grievance, we're talking about a month, which is just preposterous in a given situation.
Everyone, yeah. These days, a month is an eternity. It seems like it's been years since this all started, at least for me. And certainly, one thing I did want to mention, as difficult as, from my perspective, and what I see with my criminal defense clients, and I think you really can't undercount this, but the people, and at the best of times, people in jails and prisons have limited access to information. And in that kind of circumstance, we've certainly seen that in Louisiana when all of these, hurricanes and such strike. The first thing that starts is the rumor mill, and it's just a constant flood and it's hard not to let that get into your head. So, I really, on a personal level, really, feel for people who are stuck in these situations and they're getting so much misinformation, and it's just, he said, she said, and the psychological difficulty of weathering this pandemic in a jail or prison must be, it's hard to discount that. So, Michael, can you talk a little bit about what PJI has been doing at Angola? We had a bit of a preview from Bruce, but I know you all filed a suit involving the state's plan to move folks to Camp J.
Yeah, I'd be happy to. And Mercedes, my executive director, sends her apology. They're having a hearing on our case as we speak, I believe, right now. And so I'm an organizer, and I lead our sort of policy and advocacy work. And I'm happy to talk here because at the Promised Justice Initiative, we sort of see litigation and advocacy and organizing all as sort of hand in glove. That, if we think of ourselves as a movement that's advocating against a system of mass incarceration, that involves litigation, but it also involves community organizing and advocacy, and a strategy that, that dismisses one of those areas, either litigation or advocacy, you're sort of tying one of your hands behind your back. So we see it all as part of a whole. And just as way of background for folks who might not be familiar with Louisiana on the call. So, our Department of Corrections has about 31,600 people in custody, and around another 15,000 in pretrial in jails around the state. That's one or two in per capita incarceration rate in the country. We in Oklahoma kind of switch back and forth. I think we have it again this year. But the folks in DOC custody, there are 8 state facilities around the state. And then there are 100 local jails, or a little over 100 local jails. And about half of all people in DOC custody are actually serving their state sentences in local jails. It's an arrangement that Louisiana has between the sheriffs and the Department of Corrections. So you have people in DOC custody all around the state. The largest state facility is Louisiana State Penitentiary, commonly referred to as Angola, a nickname that it earned many years ago because when it was a plantation, that was the perceived country of origin of the enslaved people that worked there. So I believe it's the largest state prison in the country. It's about 6,000 people, mostly serving longer sentences and life sentences, life without parole. So about 50% of everyone at Angola is over 50 years old, which obviously in a time of pandemic is certainly a consideration. Even before COVID-19, there were, as Bruce alluded to, huge concerns about the access and quality of medical care at Angola. So, we spend about $2,000 per capita on healthcare for incarcerated people in the Louisiana Department of Corrections. That's the lowest per capita in the country. So as a result, not surprisingly, we have the highest mortality rate in our state prisons in Louisiana, with about 817 deaths per 100,000 people. The next highest is Alabama with 497. And as Bruce said, the Middle District of Louisiana, in their order in February, right before this all happened, said they were preparing to rule on the unconstitutional, that certain aspects of the healthcare provided at Angola were unconstitutional. So that was all before COVID. And since COVID, we've seen a reaction from our governor and Department of Corrections, and their primary plan that they put forward in terms of COVID response was to move people from around the state who had tested positive for COVID-19, who were incarcerated, to the Louisiana State Prison at Angola, reopening a formerly closed solitary confinement facility called Camp J. So, Angola, it's a massive place, the size of Manhattan. There are lots of different buildings and facilities. There's main prison, Camp D. Camp J was closed in 2018. It's about a 400-bed facility. It was used for administrative segregation and solitary confinement. It was a punishment camp for those who, had administrative citations and that sort of thing in Angola. And it was, purpose-built for punishment. It has no heat, no air conditioning. Its primary climate control is huge fans that blow the air through, which again, in a pandemic situation, presents huge concerns in terms of limiting the spread. And so Camp J has a real reputation. It's been closed for 2 years. It was closed voluntarily by the Department of Corrections for substandard conditions. And there's very little reason to suppose that in 2 years of abandonment that the conditions have gotten much better. But that was the facility that had been chosen by the Department of Corrections to bring all incarcerated people around the state who had tested positive for COVID-18 to. That includes pretrial people. So that can present huge challenges in the due process of people who are pretrial, say in Orleans, in the parish prison, being brought 130 miles away to a state facility, and it's very unclear how those people are going to, bond out if they had been eligible for that or anything like that. And so, we have a class action filed in the Middle District of Louisiana, where our named plaintiffs are people with different statuses, all who are facing transfer to Camp J, and on 14th and 8th Amendment sort of claims of deliberate indifference and cruel and unusual punishment, saying that this plan puts them at considerable danger if they have COVID-19, and for people at DOC, at Angola, for concentrating COVID-19 positive cases at the facility. At a facility, as I said, that has most of our oldest prisoner population.
Have they actually started transferring people to Camp J?
Yes, yeah. So right now, I believe there are about 80 people there. Whether or not an individual local jail decides to transfer people there is in the purview of the sheriff for pretrial. So some sheriffs are making more use of it than others. One of the issues is that by DOC's own admission, there are 0 ventilators at Camp J at Angola. So you're moving all these positive people. For folks who have been to Angola, it is, like many prisons, like Sarah was saying, very remote. So it's 60 miles from the nearest ventilator. And they will not have any at the facility. And for a while, the East Baton Rouge Parish Prison, which is 6 miles from Our Lady of the Lake Hospital, was transferring people 60 miles away to Camp J, only to have them, when they got very sick, brought back to Our Lady of the Lake. And in some instances, we're taking people out of hospitals and bringing them to Camp J, where the litigation is really is attacking this plan as one that isn't informed by public health, and puts at unnecessary danger not only people being transferred to Camp J, but also all the people who are at Angola presently. Yeah.
Yeah, I was going to say that people at Camp J, and it's also, I'm sure the staff at the prison, many of the staff at the prison are probably not thrilled with this plan. And an interesting angle, something that we haven't really talked about, but at Oakdale, the guard union actually also filed a suit about the conditions and the lack of protective equipment that they were receiving. So sort of an issue on all sides of the coin. And then just in the interest of time, let me ask, and kind of on that note, Eileen, as a person in your practice, you often represent governmental entities. A suit came, class action injunction seeking to stop the transfer of inmates to Camp J, for example, or raising issues regarding the confinement plans for treatment of COVID-19 in jails and prisons came across your desk. What would your reaction be? What would your, obviously, probably a motion to dismiss, I would guess, if I had to guess, and having been many,
Well,
a
actually,
recipient of many motions to dismiss. But
it's interesting. There's two. I saw one of the participants shared a case called Mays versus Dart, which is one of the cases that I was planning to talk about, and this one that didn't actually have to do with the transfer. And I mean, I can only speak to sort of what's happening here in the Chicagoland area, and we had two class actions going on almost simultaneously. One that was filed on behalf of prisoners that are incarcerated in the Illinois Department of Corrections. So those are convicted individuals. And then there's another one that was filed against the county and Cook County Sheriff Dart. And both were filed as temporary restraining orders leading to preliminary injunctive relief. Both sought habeas relief as well as Section 1983 relief. Though the class action against the IDOC, that ruling was made by Judge Dow. The case is Money versus Pritzker. And ultimately, the court evaluated it under both the habeas provisions and the Section 1983 provisions. And there's a very thorough discussion about both avenues. Both judges dealt with it very similarly. They addressed the class action in Rule 23 prerequisites for class certification in a preliminary form. Both mostly came down on the same side of those decisions, although the district court judge, Judge Dow, in the IDOC case found no commonality, while the judge in the Dart case, which was Judge Connelly, found commonality. So the IDOC case, though, was analyzed under Eighth Amendment case law, and obviously the standard there is deliberate indifference. And the case went to hearing, mostly I think on affidavits and such, and ultimately the court concluded that the plaintiffs couldn't show deliberate indifference, and they looked at the things of regarding what the prison was doing to address the concerns as that have arisen because of COVID. Jail population in Illinois, the jail population at the start of all of this was, or the Illinois Department of Corrections population was about 37,000. Plaintiffs were advocating for some sort of immediately release for, at a minimum, 12,000 prisoners that fit whatever class categories they thought were appropriate, that would require immediate release. But it could have been, because of the overlap, as much as 20 or 25,000 prisoners to be released. And they were careful to say, we don't mean that they should just be let go to wander the streets, and that it would still be, they weren't advocating for clemency or vacating their convictions, but that this was some kind of medical furlough is how they styled it. Ultimately, the court found that there wasn't deliberate indifference to justify this kind of extreme release of so many prisoners, and that there had been systems set up within the prison itself to address social distancing concerns and all the other things that we know we need to do to try and combat the pandemic. And so in the IDOC case, the class plaintiffs lost. I will say that since this was filed early April, let's say, the decision came down maybe the second or third week of April. As of Monday, the Illinois Department of Corrections put out a list of all prisoners that have been released since March 1st under some mechanism, all of the mechanisms available. And they have already released 4,000 prisoners in the state of Illinois. And you know, the concern, obviously, and it's a concern, I mean, the media is picking up on it now, is so of those 4,000, 64 of them are convicted murderers. So where are they? And is that a safety concern? There's also different people on the panel had talked about transferring transferring prisoners to reduce the prison population. I don't remember which one of the panelists was talking about that. Not the Camp J issue, but simply transferring. I think it might have been Sarah. And the concern about, taking COVID from one prison facility to another. I mean, that same concern is when you're releasing people from a prison population. It's no different than the cruise ships, right? When everybody came off the cruise ships, there was a huge concern about simply letting them go out into the population. I think the same thing is valid here. And I haven't heard or seen heard from any of the panelists here or seen in any of the filings that I've reviewed locally any suggestions by the plaintiffs of how to deal with that problem, right? Is if you are talking about releasing a population that we all can agree are potentially more likely exposed than anybody else because of the setting that they're being released from, how do we guard against, the home? You send somebody, where are they going to go live? They're going to go live with their family members, presumably. And, those people might have elderly people, their health conditions. So these are all things that the government has to think about too, right? I mean, it's, and they certainly, have those concerns in the back of their minds when they're acting. Then I want to just contrast that, because we're going to be running out of time here soon. Sure. with the case against Dart. So now that one, obviously, these are pretrial detainees. So that was analyzed under a 14th Amendment standard, because these are people that had not been convicted. And so Judge Connelly analyzed it not under deliberate indifference, but under the Fourth Amendment standards, objective reasonableness. And ultimately, despite the fact that Sheriff Dart has made huge strides in opening empty parts of the prison to allow for socially distant cells, so single cells, breaking down some of the dorms, the court found that it wasn't enough. But even in that regard, did not release any prisoners, simply ordered, I think by yesterday, that more efforts had to be taken and that's the Mays case, that more efforts had to be taken to ensure social distancing within the prison population. And I will say, in that regard, I think through other means, Dart has released probably 25% of the pretrial detainee population in Cook County Jail to allow for more social distancing through home electronic monitoring and things of that nature since this all began. There's a question from somebody about the list, the IDOC list. You can find it on the IDOC website. There was a article in the Tribune maybe Monday or Tuesday, and it linked to the list, but you can go right to the IDOC website. It's an Excel spreadsheet, and it identifies everybody that was released. And I think it's got the charge. I'm pretty sure it has the charge that they had been, what they'd been convicted of. And it's a searchable Excel spreadsheet if you're looking for names. Somebody just shared it, actually. Final list of exits is the name of the document that identifies all the people that have been released since March 1st from the IDOC. And then the only other point I would address, just to comment on some of the other things some of the other panelists have said about moving prisoners to a single facility, COVID positive prisoners to a single facility, and without speaking to the quality of the prison in Louisiana, because I don't know anything about it. I can say here that, there are hospitals here within certain hospital systems that have been devoted solely to COVID patients. So, within the North Shore system here in Illinois, all COVID patients go to one designated hospital. So that, and then I think that serves the purpose of obviously trying to prevent the spread to other patients in the hospital. So that thinking makes some sense. Obviously, you have to make sure that the prison that you're moving people to is medically equipped to deal with it. But, as we're, the thing that's most profound to me is that this happened so quickly, right? I can go back to the beginning of all of this, and I was supposed to be traveling, and actually thought that I was supposed to leave on a Saturday, and thought on Monday that it was still a possibility, and then the world came to a screeching halt. So it's and it's difficult just for bureaucracies generally to move quickly, and so the experience that I'm seeing here, and maybe obviously the plaintiff's bar here might have something different to say about it, is that the officials here are cognizant of the real risks and aren't interested in unnecessarily endangering anybody. But they have lots of real things that they have to think about when they're making these types of decisions.
Yeah, no, I think, that's in the interest of time, we'll wrap up here, and just a final note. I think.
I'm sorry to interrupt you. Can I just real quickly
Sure.
respond to one thing I think is important, and that is to Eileen's point about not being able to release people because of concerns about quarantining or the spread of infection once they're released. One, I have seen plaintiffs raise this issue in multiple pleadings, talking about how one of the requirements, I know we did this in our petition for master reprieve, that one of the requirements of the release would be following the health orders of the state. I think there are ways around this. No defense counsel has raised this. The ODRC has not raised this with me. The parole board has not raised this. Clearly, the governor has not raised this, but they haven't responded to us in any way as that being a concern. I think it's a real red herring. We have to decide whether we're going to leave people to languish and die in pain and live in with this terror of a pending infection, particularly when we're looking at a very vulnerable population, similar to nursing homes. In fact, more dangerous than nursing homes because of the crowded conditions and because of the comorbidities that exist within these prisons. So either we leave them to languish and die without doing anything to support them, to allow people to go out where they can, if they have to self-quarantine, just like many of us have self-quarantined when we or other family members have shown signs of infection, put yourself in a room. Now, there are other issues here around people lacking access to housing and crowded housing conditions, all of that. And that is significant to consider. But for the government to claim that that is a reason why we cannot release people from death chambers inside these prisons at this point is asinine. People can go.
I'm going to just interrupt you for just 1 second.
Of the health orders of the state, and take responsibility to keep themselves and other people in society and their communities as safe as possible.
So I'm just gonna just to one point, they're not death chambers, right? So let's put it into the perspective of what the pandemic shows. Not everybody dies, and people will die in the same way when you let these people out. There's a story out of Florida that immediately after a release, a murderer that had been convicted was then charged with another murder the very next day. So all I'm suggesting is, it's not so easy to simply open the prison doors. And I don't think any of you, maybe I'm wrong, but I don't think any of you are actually advocating for simply opening the prison doors and letting everybody out because there's a concern about a pandemic. And I don't think that's a responsible way for any of us to behave. I think that we need to do what has to be done to ensure the most safety that we can ensure, cognizant of the constraints that we all operate under, both logistically for the facilities, and also in terms of what exactly, it's a legitimate concern to know what you're going to do with all of these people if you're going to release them. That was my point.
Hey,
So
what's happening at Oakdale, they are releasing the Attorney General Barr's memos. He's got 2 of them. The second one was basically, the first one was let's start looking at releasing people. The second one was, hey, I meant it, and here's where we need to start releasing them from. But part of what's happening at Oakdale is they are releasing people. It's a very slow process, and not many people are getting out. But the people who are eligible for release, they're putting them in quarantine for 14 days prior to the release. So, I mean, that to me is it's a public health expert type question that not sure that any of us as attorneys are, we can have our opinions and our thoughts and stuff, but we're not really the experts to answer how you do that. But this panel is really interesting. I mean, these are incredibly difficult questions in a ever-changing landscape. So I'll just kind of leave with the thought that I remember when I was in law school still up in Chicago, learning something from an attorney named Ben Wolf, who was an ACLU attorney. Eileen, you might remember him, but was in a deposition about the Chicago schools and got very contentious, and he kind of stopped at one point and leaned back in his chair and went off the record and said, sometimes there have been many occasions where I've ended up being the best friend for people on the end. The people I'm suing, they end up loving me because I can help you to get to a common goal. And I think, hopefully that may be where some of this litigation ends up, where we're actually addressing this public health issue that's going to affect everyone, already is affecting all of us now. So lots of different ways to approach it, lots of different viewpoints, but in any event, thank you. And that's everyone, and I'm happy to stay on and talk if we'd like, but I think that would conclude the CLE portion.